सर मेरा गुड इवनिंग सर। सर मेरा यही क्वेश्चन था कि फिर से कि अगर हम लोग को जैसे कुछ समझ में नहीं आ रहा तो हम लोग क्या जिसमें हम लोगों ने जैसे अगर रफ में या कोई भी ड्राफ्ट स्पीच का जहां लिखा है वो क्या उसमें 1 सेकंड देख सकते हैं कि हाँ लग जाए कि क्या हम लोग भूल रहे हैं क्या कहाँ अटक रहे हैं।
Good evening, everyone. I'm Gurleen Kargil. I'm here as a volunteer for Nyayvani Voice for Justice 2025, proudly organized by the Lawlicious Committee. Throughout this event, I'll be helping you with announcing the participants' names. So, our first participant is Pragya Kumari. I invite Pragya Kumari. Please come forward and especially please on your cameras. Everyone, I request.
Should I start now, ma'am? Hello. Hello.
Yes, Pragya, you can continue. You are audible.
Okay. Good evening, everyone. Today I'm Pragya. Today I'm here to discuss about the very pivotal and controversial topic that is Uniform Civil Code, which is also referred as a UCC. The concept of UCC is introduced by Dr. B.R. Ambedkar in the Constitutional Assembly in November 1948. The concept of UCC it is stated under Article 44 of the Indian Constitution, which is a part of directive principle of state policy, uh, which guiding the state and central government to promote the welfare of the citizen. The UCC is very controversial, and when the concept of UCC introduced in the Constitutional Assembly, it sparked a debate in Constitutional Assembly, and it divided the Constitutional Assembly in two parts, which is proponent and opponent. Uh, some argument in the favor of the UCC, like UCC aim to create a common law, and primary aim of UCC to achieve a gender equality, like in many personal law, which is disadvantageous for women. Now we'll take example with the case of Ahmad Shah versus Shah Bano case in 1985. In this case, a 19-year-old woman claim for maintenance from her husband. The Supreme Court judgment is in the favor of the Muslim women Sahbano, that women can claim maintenance from her husband, but under 125 section of CRPC. But this verdict of the Supreme Court is against the Muslim personal law, which is Sharia law. In Muslim personal law, women cannot uh, cannot claim for maintenance from her husband. Now we'll see about these things that in personal law of women cannot claim even maintenance from a husband. This is also gender inequality, and the aim of the UCC to achieve a gender equality and to resolve the inequalities. Now some argument in against of the UCC. Many Orthodox Hindus and Muslims think and have a fear to lose their personal laws, and to to lose their fundamental right, which is provided under the article 25 to 28 in our constitution. And now we'll come to the conclusion part. The UCC is not just a concept; it's also a step to a realization of spirit of our constitution, and like justice, unity of all the citizen of our country, regardless of their religious customs and communities. UCC aim to create a common law for all religion and all community, and unify the all personal law of different religion and different community. Thank you.
Thank you, Pragya. So now I invite Prasoon Pathak to present his views. Yes, sir. Our next participant is Prince Kumar. Prince Kumar. Now, now I invite Rajneesh.
Hello, good evening to the respected judges, coordinator, and all my dear friends. तो जैसा कि मेरा नाम रजनीश है और आज मैं यहाँ पे यूसीसी यूनिफॉर्म सिविल कोड अ कॉन्फ्लिक्ट बिटवीन रिलीजियस फ्रीडम एंड इक्वालिटी। तो मैं अपनी स्पीच शुरू करने से पहले आप सबसे क्वेश्चन पूछना चाहता हूँ कि जैसा कि बोला जाता है कि मेन एंड वुमेन आर इक्वल, तो क्या वाकई में सारे पर्सनल लॉज में वुमेन्स के जितनी हम प्रिविलेज दे रहे हैं उतनी हम मेन को ज़्यादा दे रहे हैं, वुमेन्स को उतने नहीं दे रहे हैं? तो यही एक कॉन्सेप्ट है जो यूनिफॉर्म सिविल कोड लेकर के हमारे बीच में आता है। जैसे कि इंडिया एक डाइवर्स कंट्री है और यहाँ पर हम देखते हैं कि इंडिया में बहुत सारे पर्सनल लॉज हैं। हिंदू पर्सनल लॉज अलग हैं, मुस्लिम पर्सनल लॉज अलग हैं और यही सारी चीज़ें चलती हुई आ रही हैं। अब हमारे उनमें सवाल ये खड़ा होता है कि आखिर जो यूनिफॉर्म सिविल कोड है इसका आइडिया आया कहाँ से? क्योंकि किसी चीज़ का जो भी हो वो एक कोई आइडिया आता है। तो यूनिफॉर्म सिविल कोड जो है ये कोई नया आइडिया नहीं है, ये हमारे कॉन्स्टिट्यूशन मेकर्स ने उसी समय इंट्रोड्यूस कर दिया था जब वो कॉन्स्टिट्यूशन को ड्राफ्ट कर रहे थे। बस उन लोगों ने इसे हमारे एक फंडामेंटल राइट में ना रखकर एक डीपीएसपी में रखा। डीपीएसपी जिसे हम डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी बोलते हैं, जो ऐसा रहता है कि जब स्टेट को लगेगा हमारी कंट्री उतनी कैपेबल हो जाएगी कि हम उसको इम्प्लीमेंट कर पाएंगे तब कर दिया जाएगा। अब फिर बात ये उठती है कि अगर यूनिफॉर्म सिविल कोड हर एक को इक्वलिटी लेकर के आना चाहता है तो फिर उसके साथ में दिक्कत क्या है, वो क्यों इम्प्लीमेंट नहीं किया जा रहा है। क्योंकि अब इसी में हम बात कर लेते हैं कि उसको इम्प्लीमेंट हम क्यों नहीं कर पाते हैं। क्योंकि अगर हम इम्प्लीमेंट करना चाहते हैं तो सबसे ज़्यादा ये मुस्लिम लॉ के साथ में कॉन्ट्राडिक्ट करता है। क्योंकि जहाँ पर हम देखते हैं मुस्लिम लॉ के में मेंस को ज़्यादा प्रिविलेज मिल रही है कंपैरिजन टू वुमेन। एक जो मेन है वो 4 शादियाँ कर सकता है, लेकिन एक वुमेन नहीं कर सकती है। वहीं पे अगर हम डाइवोर्स के ग्राउंड्स की बात करते हैं तो मेन को ज़्यादा मिले हुए हैं, उतनी औरतों को नहीं मिले हुए हैं। और इसी का एक हमारे पास में रियल लाइफ एग्जांपल्स में हम देखते हैं शाहबानो का केस, जिसमें शाहबानो केस में एक 62 ईयर ओल्ड की एक वुमेन होती है, जिसको उसका जो हस्बैंड होता है वो डाइवोर्स दे देता है। और फिर वो जाती है कोर्ट के पास में मेंटेनेंस क्लेम करने के लिए। तो पहले तो उसको केस को कोर्ट अपहेल करता है, उसमें वो जीत जाती है। लेकिन फिर बाद में जब वो सुप्रीम कोर्ट के पास में जाती है तब उसके केस को डिसमिस कर दिया जाता है और शाहबानो को जो जस्टिस होता है वो नहीं मिल पाता है। फिर इसी में हम बात करते हैं, हमारे पास में एक रियल लाइफ एग्जांपल्स में आता है ट्रिपल तलाक। तो ट्रिपल तलाक में क्या होता था बेसिकली कि अगर कोई भी एक मुस्लिम मैन जो है वो 3 बार तलाक 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 बोल देता था तो उसको मान लिया जाता था कि वो तलाक हो गया है। तो यही सारी बहुत सारी सोशल इनइक्वालिटीज़ थी, या जिनको हम सोशल इविल्स भी बोल सकते हैं, जो मुस्लिम लॉ में फॉलो हो रही थी। अब तो फिर तभी बात आती है जैसे कि 2019 में उसको लेकर के आए और हटा दिया गया, ट्रिपल तलाक को हटा दिया गया। अब जैसे कि फिर वहीं पे हम देखते हैं कि गोवा जो कि एक इंडिया का ही स्टेट है, उसमें ऑलरेडी इम्प्लीमेंट कर दिया है यूसीसी को, और वहाँ पे सारी चीज़ें देखने को मिलती हैं। अब फिर हम वहीं पे इसको थोड़ा सा हम रिलेट कर सकते हैं, क्योंकि जब हम देखते हैं कि फंडामेंटल राइट हमेशा ही प्रिवेल करता है डीपीएसपी के ऊपर। जो आर्टिकल 25 है वो रिलीजियस फ्रीडम देता है हर एक को। तो इसी के ज़रिए वो हम देख पा रहे हैं। अब इससे हमको एक थ्योरी मिलती है, अगर हम इसको थोड़ा-सा जूरिस्प्रूडेंस के साथ रिलेट करना चाहें या थ्योरी के साथ रिलेट करना चाहें, तो हमको एक वॉक जिस्ट की थ्योरी मिलती है, जो कि सेविनी ने दी हुई थी, जिसमें उन्होंने कहा था कि जो लॉ होता है वो पीपल की स्पिरिट में रिफ्लेक्ट होना चाहिए और उनके कल्चर में होना चाहिए। तो अगर हम यूसीसी के साथ में इसको रिलेट करेंगे तो उसमें देखेंगे कि यूसीसी जो है वो लोगों के ग्रोथ के साथ में आना चाहिए, वो उनके ऊपर फ़ोर्स नहीं किया जाना चाहिए। अब अगर हम इसी की बात करते तो हम लेजिस फेयर व्यू भी हमको देखना चाहिए, क्योंकि इसमें हम लेजिस फेयर में क्या होता है बोलते हैं कि लोग जैसे रहना चाहते हैं हमको वैसे रहना चाहिए और गवर्नमेंट को इंटरफेयर नहीं करना चाहिए। लेकिन हम उन ट्रस्ट और उन ट्रेडिशंस का क्या करेंगे अगर वो दो मेन और वुमेन के बीच में इनइक्वालिटी लेकर के आ रहे हैं। तो इसी के लिए हमको यूनिफॉर्म सिविल कोड इम्प्लीमेंट करना चाहिए, जिससे कि हम वुमेन्स को भी जो मुस्लिम हैं इनहेरिटेंस सक्सेशन और मैरिज के भी प्रॉपर लॉज दे पाएँ और वो रखें। और यही हमको लॉज ऐसे चाहिए जो हमको यूनाइट करें, ना कि डिवाइड। और आर्टिकल 44 जैसा कि डीपीएसपी है तो अभी तक इम्प्लीमेंट नहीं हो पाया है, लेकिन फिर भी वो कहीं जगह पे रखा जा रहा है और हमें देखना चाहिए कि थैंक यू।
Thank you, Rajneesh, for your meaningful insights. Now I invite Ram Vardhan Singh Rathore to take the stage, please.
Honorable judges, as we gather today to discuss one of the India's most pressing constitutional dilemmas, let me ask, can a country truly call itself just and equal when its laws differ based on religious affiliations? It is merely a debate about religion. It's a fundamentally about rights, affiliation, justice, and the very essence of a democracy. Article 44 of our Constitution explicitly directs the state to secure a uniform civil code throughout India's territory. Yet today, we operate under a complex legal framework where personal laws vary significantly across religious communities. While Article 14 guarantees equality before law, Article 25 protects religious freedom, creating what appears to be an irreconcilable paradox. Let me ask, how many of you would accept a different speed limit based on their religion while driving to court? Would you find it amusing if some citizen could drive 100 km per hour while others were restricted to 60 km per hour simply because of their faith? A journey towards legal uniformity began during colonial rule when British administrators adopted a policy of non interference in religious matters. Post-independence, significant milestones marked our progress. In 1955 to 1956, the Hindu Code Bills revolutionized personal laws for Hindus, Buddhists, Sikhs, and Jains. And 1961, the Shabano case. Let me ask, would you accept a different marriage age for your daughters based on their religion? Would you find it amusing if your 15-year-old Muslim daughter could legally marry into a Hindu religion based on the religion? Would you find it amusing if your 15-year-old Muslim daughter could legally marry into your Hindu neighbor daughter must wait until 18?
कुछ listen कर लिया
Today, our legal system perpetuates glaring inequalities. Hindu girls must wait until 18 years old. Muslim girls can marry at puberty, and Christians and Parsi women must face varying restrictions. Hindu women enjoy equal inheritance rights since 2005, but Muslim women receive half of the shares of male siblings, while Christian women face discrimination under outdated succession laws. Triple talaq remains controversial despite Supreme Court interventions, and maintenance rights vary significantly across religious communities. Let me ask, how would you explain to a Muslim woman who receives half the inheritance of her male siblings that this discrimination is constitutional? Would you tell that her fate demands less equality? Our global peers offer invaluable insights. Turkey, for example, successfully implemented UCC while maintaining religious diversity. Tunisia reformed personal laws to enhance women's rights, and Canada balances secular principles with cultural sensitivity. Let me ask you, how does our secular democracy have religion-based civil laws but one criminal law? Is it because murder is more serious than marriage? Here's a proposed solution. We don't need to enforce UCC in one sweeping move. We can start with common issues like inheritance, maintenance, and minimum marriage age. Let the UCC exist alongside personal laws, allowing citizens to opt in over time. Codify and reform personal laws across all faiths, keeping the cultural soul while removing the discriminatory spine. Engage tribal communities protected under Article 371 and prioritize gender justice, as most of the most personal laws discriminate against women. If our constitution cannot protect half of its citizens, then what is the use of the law? Let me ask you, if India isn't ready for equal rights in 2015, when it will be, after another 25 years of independence? As Dr. B.R. Ambedkar said, the Constitution isn't a mere laws document, it is a vehicle of life. Yet today we stand at a critical juncture where tradition confronts transformation. The choice before us is stark. Do we remain a museum of outdated customs, or do we evolve into a temple of equal laws? Do we carry forward colonial era compromises or rise of constitutional ideas of equality, liberty, and dignity? Uniform Civil Code isn't about imposing uniformity of religion, it's about establishing uniformity of rights. It's not about erasing cultural identity, it's about ensuring constitutional equality. As we stand here today, let us remember that justice delayed is justice denied. India must decide, will we continue to shelter discrimination behind religious freedom, or will we embrace the courageous to reform? The Constitution didn't envision a nation where rights vary based on religious affiliation. It envisioned a nation where justice knows no religion, where equality embraces all citizens equally. Let us fulfill this vision, not fear it. Let us choose constitutional morality over convenience, justice over tradition, and equality over exception. Thank you.
Thank you, Ramvardhan. Next up is Ritesh Kumar.
यस मैम। नमस्कार, मैं रितेश कुमार। आज मैं आपके सामने एक महत्वपूर्ण विषय पर समान नागरिक संहिता पर अपने विचार प्रस्तुत करने जा रहा हूँ। यूनिफॉर्म सिविल कोड का अर्थ है कि भारत के हर नागरिक के लिए एक समान कानून हो, चाहे वह किसी भी धर्म, जाति या समुदाय से संबंधित क्यों न हो। यह कानून विवाह, तलाक, संपत्ति के अधिकार, गोद लेने और विरासत जैसे निजी मामलों में समानता लाएगा महिलाओं को जो है पहले का जब फर्स्ट लॉ कमीशन बना था उस समय महिलाओं को हम लोग प्रोवर्टी नहीं देते थे, ना उनको किसी भी सामान में हक देते थे। पुरुष को ही जो जमीन है वो जमीन में हक नहीं देते थे, महिलाओं को उतना प्रोवर्टी नहीं था। हमारा संविधान सभी नागरिकों को समान अधिकार देने की बात करता है, लेकिन आज भी भारत में अलग अलग धर्मों के लिए अलग अलग पर्सनल लॉ है, जो कई बार असमानता और भेदभाव को जन्म देता है। यूसीसी का उद्देश्य है इन सभी पर्सनल लॉ को हटाकर एक समान कानून लागू करें। अगर हमारे देश में यूसीसी लागू हो जाता है तो हम हिंदू मैरिज एक्ट 1955 का है, हिंदू सक्सेशन एक्ट 1956 का जो बना, हिंदू मिनिटी एंड गार्जियनशिप एक्ट 1956 का है, हिंदू एडॉप्शन एंड मेडिएशन एक्ट 1956 का है, क्रिश्चियन मैरिज एक्ट है, हिंदू इंडियन डिवोर्स एक्ट है, मुस्लिम पर्सनल लॉ एंड शरिया लॉ है 1937 का, मुस्लिम मैरिज एक्ट 1939 का है, स्पेशल मैरिज एक्ट 1954 का है। ये सब कानून लागू खत्म करके हम एक कानून को लागू करेंगे जिसके तहत सबका होगा। जैसे में आज के डेट में इंडिया में हम बीएनएस लाए, भारतीय न्याय संहिता, जिसके तहत एक एथी है, उसमें 102 एक एथी है, सेक्शन है, जिसके तहत मृत्यु होता है तो हिंदू भी अगर मर्डर करेगा तो उस पर भी सेम कानून लागू होगा 102, मुस्लिम भी करेगा तो उस पर भी सेम कानून लागू होगा। ये कहीं भी नहीं देखा जाता है कि अगर हिंदू शादी करेगा तो फिर उसके लिए हिंदू मैरिज एक्ट है, मुस्लिम करेगा तो मुस्लिम मैरिज एक्ट। उससे अच्छा है कि एक कानून लागू होगा। तो कुछ लोग, यानी अधिकतर इसमें जो मुस्लिम लोग हैं, यह मानते हैं कि यूसीसी अगर लागू हो जाएगा तो धार्मिक स्वतंत्रता में हस्तक्षेप होगा, जबकि ऐसा नहीं है। लेकिन यह बात समझनी जरूरी है हम लोग को कि यूसीसी किसी भी धार्मिक मान्यता को खत्म नहीं करता है, बल्कि कानून का एक सम्मान बनाता है। इसका उद्देश्य है लैंगिक समानता, न्याय और आधुनिक भारत का निर्माण करना। लेकिन फिर भी कुछ लोग बोलते हैं कि ये हमारी धर्म का स्वतंत्रता छीन लेता है। उन लोगों को बता दें कि यूसीसी कितना ऐसा देश है जो मुस्लिम खुद देश है उसमें भी लागू है। जैसे अमेरिका में यूसीसी लागू है, आयरलैंड हो गया। सबसे बड़ा देश मुस्लिम पाकिस्तान है, इंडोनेशिया है, इसमें भी लागू है। बांग्लादेश है मुस्लिम, उसमें भी लागू है। मलेशिया है, तुर्की है, सूडान है, मिस्र जैसे भी देश में यूसीसी लागू है। और भारत के अभी विभिन्न 2 राज्य हैं, वहां पर भी यूसीसी लागू है। सबसे पहले गोवा है जो 19 दिसंबर 1961 को लागू हुआ। फिर उत्तराखंड 27 जनवरी 2025 को लागू हुआ। से पूरे राज्य में लागू हो जाएगा तो यूसीसी कोई बड़ी बात नहीं है। इससे जो हम लोग का हिंदू है, पहले था कि आज हिंदू पुरुष है वो विरोध करता है कि नहीं, हमको हिंदू मैरिज एक्ट नहीं रहता तो हम 4 शादियां करते। जो मुस्लिम महिला है वो लोग विरोध करती है, सेम वो पुरुष का हाल हो गया है हिंदू मैरिज एक्ट में। वैसे है, इसमें सुप्रीम कोर्ट भी कितना कई मामला ऐसा है जिसमें सुप्रीम कोर्ट खुद बोला है कि नहीं आप यूसीसी लागू कीजिए। जैसे में ज्ञान बल्टम बना भारत संघ के मामला में मुख्य न्यायमूर्ति श्री बी एन खड़गे के सामने सिविल संहिता मामले की सिफारिश किया था उसमें। और ऐसा नहीं है कि हमारा कॉन्स्टिट्यूशन जो है वो भी आर्टिकल 44 में दिया हुआ है कि सिविल संहिता लागू हो समान रूप से। साहबानों के मामले में जस्टिस यशवंत विश्व विष्णु चंद्रचूड़ ने भी थी, उसने भी यूसीसी लागू करने के मांग उठाए थे। सारला मुद्दल केस जो 1995 का है, दो विवाह का केस, इसमें भी यूसीसी के लिए हम लोग रिक्वायरमेंट किए थे। अगर यूसीसी लागू हो जाता है तो हमें प्रतिशील समानता आधारित हर किसी को न्याय मिलने के लिए इसमें एथी होगा। और इससे भारत जो है वो अपने आप में एक विकसित देश बनेगा। यहाँ पे जो अन्य मामला है वैसा मामला यहाँ पे कभी नहीं होगा। जैसे में एक हिंदू है तो उसका रीति रिवाज से विवाह किया, एक मुस्लिम है वो किसी और एथी से विवाह करेगा, इससे कोई दिक्कत नहीं है। डिवोर्स का इसमें सबसे ज्यादा हानि मुस्लिम में लड़की लोग का है, जो एक हलाला होता था, जो एक मुस्लिम शादी किया फिर उसके बाद दूसरा किसी से करेगा तो अवैध संबंध बनेगा। ये सब खत्म होगा इसके चलते। बाकी दूसरा इसमें कुछ एथी नहीं है। थैंक यू।
Thank you, Ritesh. Now I invite Sankalp Tiwari. Sankalp, you are not audible to everyone. Please on your mic. Now we have Shriyanshi Tiwari.
Shall I begin now? I'm audible? Okay. So, good evening to the honorable judges, the fellow organizers, and my learned panelists. And so today, when we talk about the topic, I would be talking against the topic, and I would like to start by a quote from Mahatma Gandhi. So Mahatma Gandhi had once said that diversity is not India's weakness; it is a strength. And today, as we talk about UCC, we must ask ourselves: are we really promoting and fostering equality, or are we just eroding the very identity and the very freedom that defines our nation? At the very start, let me state this very clearly that UCC in its current form is not a bridge towards equality, and rather it is a bulldozer to the religious freedom and the federalism of our country. The personal laws that govern the marriages, the divorces, and the inheritance areas in our nation, they aren't just merely customs. They're actually a very intrinsic part of the religious and the cultural identity of the diverse communities that exist within our nation. And even if you look at our constitution, from articles 25 to 28, our constitution says that every citizen, every individual has a right to freely profess, propagate, and practice whatever religion that they choose. And there's meher in Muslim families. There are various tax benefits that are available within the Hindu joint family structures. And so these type of practices, they are not, merely anomalies. They're actually a very intrinsic expressions of a deeply held belief. And so even if a person or an individual has to go for a secular alternative, there already exists a Special Marriages Act. And so when there already exists a more secular alternative, what is the need for actually imposing a code that overrides the personal laws? Is uniformity more important than individual freedom? I really don't think so. And moreover, when we consider the problem of UCC, we should also consider that we live in a country which has very large amount of small tribal communities that are spread in various areas of our nation. We are not just a country of Hindu, Muslims, Sikh, Jains, etc. We very much have people that exist in tribal groups and in Bihar, in Assam, and other such areas. And within these tribal communities, there are very prevalent customs that they have been sustaining since ages. Even our constitution safeguards these customs. For example, the Article 371A, it safeguards the tradition of Nagas from Nagaland, and it ensures that no act of the parliament, can no act of the parliament would apply to the social customary laws and practices of Nagas in Nagaland, and unless state legislature says so. And the same protection is available for people of Mizoram too under Article 371G. And so when UCC is looked at in this context, UCC poses a threat to such tribal communities and their customs. In the previous hit in 2024, when the UCC code was introduced in Uttarakhand, we could see that there was a prevalent backlash by many tribal communities like Tharu community, the Bhutia community, and their main reason for backlash and protests were that they felt that their customs and their practices, their identity as such was being disregarded. And so all of this just deeply reflects the tension that exists between the UCC and the religious autonomy that individuals in our country have. And the alienation of their identities is not the solution that we are actually hoping for. One of the panelists also, I think, mentioned the Shahbanu case. Even if you look at the Shahbanu case, what happened there? The poor Muslim woman was granted an alimony under Section 125 of the CRPC. What happened? It led to a large amount of protest and backlash. It eventually had led to the formation of the Muslim Women Protection of Rights and Divorce Act, and this had actually curtailed the rights of the court. What this shows that even if a well-intended, intervention or a reform, this can backfire when it is perceived as intrusive, and this can further polarize the society. So what we should do is ask ourselves that we as a country, we have established our name because of the symphony of our coexistence. Okay, okay, thank you.
Thank you, Sankalp. Next, we have Shriyanshi Tiwari. I repeat, Shriyanshi Tiwari. Now I invite Shubham Raj.
हेलो हेलो मैं ऑडियो गुड इवनिंग सर। आई एम शुभम राज। आज मैं एक ऐसे मुद्दे पर बोलने जा रहा हूँ जो हमारे संविधान, हमारी पहचान और हमारे विचार तीनों से जुड़ा हुआ है। यूसीसी, यूनिफॉर्म सिविल कोड। इसका सिंपल लैंग्वेज में जानते हैं यूसीसी होता क्या है। यूसीसी का मतलब होता है एक कॉमन सिविल लॉ जो सभी भारतीयों के लिए भारतीयों के लिए है, चाहे वो हिंदू हो, मुस्लिम हो, सिख हो या क्रिश्चियन हो। ये लॉ पर्सनल मैटर में अप्लाई करेगा, जैसे कि शादी, तलाक, विरासत और गोद लेना। इसका मेन आइडिया ये है कि सबके लिए एक जैसा कानून होना, इक्वेलिटी बिफोर लॉ, नो स्पेशल ट्रीटमेंट एंड नो डिस्क्रिमिनेशन। ये थॉट आर्टिकल 14 से इंस्पायर्ड है, राइट टू इक्वेलिटी। लेकिन इसी के साथ हमारे कॉन्स्टिट्यूशन आर्टिकल 25 में यह है कि फ्रीडम टू रिलीजन। ये हर सिटीजन को अपनी रिलीजन फ्रीली फॉलो करने का हक देता है। तो यहीं पे एक कॉन्फ्लिक्ट शुरू होता है। क्या हम एक ऐसा सिविल लॉ बना सकते हैं जो बिना किसी के रिलीजन को इफेक्ट किए बिना काम करे। इस पे सुप्रीम कोर्ट ने भी कई बार कमेंट किया है, जिसमें सबसे फेमस केस है शाहबानू केस 1985। इस केस में एक मुस्लिम वुमेन शाहबानू ने अपने पति से तलाक के बाद मेंटेनेंस मांगा। कोर्ट ने कहा कि उन्हें मेंटेनेंस मिलना चाहिए क्योंकि यह उनका लीगल राइट है, चाहे उनका पर्सनल लॉ कुछ भी करे। लेकिन इस जजमेंट के बाद काफी प्रोटेस्ट हुआ। रीजनल ग्रुप ने ये कहा कि ये उनका पर्सनल लॉ है, इसमें कोई इंटरफेरेंस ना हो। जिसके बाद गवर्नमेंट ने मुस्लिम वुमेन्स के लिए प्रोटेक्शन ऑफ राइट ऑन डिवोर्स एक्ट 1986 पास किया, जो कोर्ट के डिसीजन को ओवरराइड करता है। यह केस क्लियरली दिखाता है कि किसी जैसा इशू सिर्फ लीगल नहीं, डिपेंड डीपली इमोशनल और पॉलिटिकल भी होता है। क्या हम अपने ट्रेडिशन को मॉडर्न वैल्यू के साथ बैलेंस कर सकते हैं? क्या हम एक ऐसा लॉ बना सकते हैं जो सबको इक्वल ट्रीट करे बिना किसी के रिलीजन आइडेंटिफिकेशन को क्रश किए? मुझे लगता है हाँ, हर ध्यान से ताकि किसी को इससे कोई परेशानी ना हो। हम जो भी काम करें उसमें उसमें सबका सहयोग हो, संवाद से आना चाहिए, वोट से नहीं आना चाहिए, अंडरस्टैंडिंग से ये चीज आना चाहिए। हमें एक ऐसा यूनिफॉर्म सिविल कोड की जरूरत है जो जेंडर इक्वलिटी को प्रमोट करे, माइनॉरिटी की आइडेंटिटी को रिस्पेक्ट करे और सभी रिलीजन को फेयर के बीच फेयरनेस लाए, ताकि सब रिलीजन एक जैसे रहे, किसी को किसी से प्रॉब्लम ना हो। ये तभी पॉसिबल है जब रिफॉर्म ट्रांसपेरेंट के जरिए आए, बिना किसी फेयर के, बिना किसी बहस के और बिना किसी प्रॉब्लम के। यूनिफॉर्म सिविल कोड सिर्फ एक रिफॉर्म नहीं, ये एक नेशनल कॉन्वर्सेशन है ऐसा कॉन्वर्सेशन जिसमें सभी का आवाज हो, कोई किसी से ऊपर नहीं, कोई किसी से नीचे नहीं। ये एक ऐसा कोड हो जो सभी को एक जैसा, एक देखने पे, एक नजरिए पे, एक पहचान पे सबको एक साथ लाए। थैंक यू।
Thank you, Shubham. Now, next we have Smriti Mishra.
A very good evening to respected judges, fellow speakers, and my dear audience. I am Smriti Mishra, second year law student at Lucknow University. Today, I want you all powerful constitutional conflict which exists between the deep roots of the religious freedom and between the dream for the equality. Let me begin my speech with a very interesting story. There's a brother and a sister who have been brought up and born in the same country, in the same home, and have been taught the same values. But later on, when they grew up, the sister is told, see, you are not equal to your brother. Your brother has gotten more rights, more power, and more voice as you because he's a man and our religion allows for it. Unfortunately, this is not a story, but a reality. And this reality has got a name called the personal law, which differ from one religion to another, specifically from gender to gender. But fortunately, we have a promise enshrined in Article 44 of our Indian Constitution as the directive principle of the state policy, and it is Uniform Civil Code. It is not a sword, it is not a threat, but a hope for one law and one justice for every citizen. But this promise stands at a crossroad where one side is the religious freedom and the other side is the right for the equality. And in between both, there is a constitution silently watching its values getting clashed. Our constitution talks of two very important things. The first thing is that no law shall bring inequality, and the second one is that no right shall silence any kind of religion. But what if any religion brings inequality? We have triple talaq, we have polygamy, we have unfair inheritance, we have customs that chain women behind the bars. Do we still call it a culture, or it is just that we have a habit of getting injustice? Let me make one thing very clear that this is not a Hindu Muslim debate. This is not a debate of a tradition versus modernity. It is a human rights debate. It is a debate of justice versus injustice. Uniform Civil Code, it does not target any one religion or it doesn't about imposing one religion over another. It is not about bringing uniformity in the rituals and the prayers, but it is about bringing uniformity in the civil matters such as marriage, adoption, inheritance, etc. It is not a hammer. It is a bridge between the tradition and the truth, between the faith and the fairness, and we must walk that bridge very carefully. We have already made progress in the past, like in the case of Saira Banu versus Union of India. Our Honorable Supreme Court held triple talaq unconstitutional, and also all the Hindu personal laws they were codified. So why I want to ask that why such kind of justice remain restricted to only one religion? Change should not be forced, it should be felt. Reforms must not be enforced. it should be invited. Similarly, laws must not divide, it should unite. As a second year law student, I have read the Constitution not just as a book, but as a dream written in the legal ink. And in that link, and in that dream, I saw a sister finally getting equal rights as her brother, not just in the hope, but in the law. But in the law. I would like to end my speech by saying that justice is not blind. It is just tired of getting waited. Let's not write another article. Let's write a revolution called the Uniform Civil Code. Thank you, Jai Hind.
Thank you, Smriti. Next, I invite Sonali Gupta to speak.
Hello, Namaste, Adab, Sat Shri Akal to the respective judges and authorities and my worthy opponents. It's an honor to present myself before you today. I'm Sonali Gupta, fourth year law student of Deshbhagat University, Mandi Gobindganj, Punjab, and I'm truly grateful for the opportunity to speak before you about Uniform Civil Code and the basic structure, a conflict between equality and religious freedom. Whether you are here out of curiosity, passion, or purpose, I hope to share a perspective that that resonates with you, speaks ideas, and maybe even shifts the way you see the world. So let's dive in. Article 44 of the Indian Constitution, part of the directive principles of state policy, calls upon the state to secure a uniform civil code for all citizens. At the same time, Article 25 to 28 guarantee freedom of religion. The crux of the issue is whether implementing a UCC violates the basic structure of the Constitution by infringing upon religious freedoms, or whether it strengthens the structure by promoting equality and secularism. So, what's basic structure of doctrine? Established in Keshavananda Bharti case in 1973 holds that certain features of constitution such as secularism, democracy, rule of law, fundamental rights cannot be altered even by constitutional amendment. Any legislation or policy must pass the doctrinal threshold. What literally the UCC will do? A uniform civil code possesses a set of common personal laws applicable to all citizens regardless of religion, covering areas like marriage, divorce, adoption, inheritance, etc. Your UCC is grounded in the principle of formal equality, aiming to remove disparities and discriminatory participations in personal laws. How our Indian religions are working under the law? Indian personal laws are deeply embedded in religion. Hindu law, codified in 1955-1956, governs Hindus, Buddhists, Jains, Sikhs. Muslim personal law, largely uncodified, is governed by the Shariat. Christian and pastoral law have their own codes. Article 25, Clause 1 guarantees the right to freely profess, practice, and propagate religion. But this right is subject to public order, morality, and health. Article 25, Clause 2, Clause A permits the state to regulate to regulate or restrict secular activities associated with religious practice. The judiciary has often distinguished between essential religious practices and secular aspects. In Shirur Muth 1954, the Supreme Court laid the foundation of the test. How the equality under the law and religion are conflicting. Many personal laws discriminate against women. For example, triple talaq, now declared unconstitutional in Sharia Banu versus Union of India 2009-17 case, unequal inheritance rights under Muslim law, polygamy in some religion laws. These days, constitutional question: can religious freedom justify discrimination? The court in Indian Young Lawyers Association versus State of Kerala 2018, the Sabrimala case, underscored that not equality and dignity of women are not non-negotiable part of the constitution. What are the thoughts of judiciary about the same? The Supreme Court has time and again advocated for the UCC. In Muhammad Ahmad Khan versus Shah Banu 1956, the court expressed regret over non-implementation of Article 44. The Sarla Mudgil versus Union of India 1955, it called the urgency of UCC to prevent abuse of personal laws. According to secularism, as per Indian constitutionalism, does not mean infringe but equal respect for all religions. In SR Bomai versus Union of India 1994, secularism was held as part of basic structure. A UCC is implemented respecting religious diversity and not imposing majoritarian values can align with secularism. Equality before for religion means that no religion should stand above the constitution, and all citizens must be treated equally regardless of their religious identity, not just in public but within the religious practices themselves, especially when those practices affect the civil rights. Because in Indian context, religion governs many personal matters like marriage, divorce, adoption, inheritance. If religious practices or personal laws result in discrimination, particularly against women, LGBTQ plus persons, or minorities within religions, then the principle of equality before law demands that constitutional equality prevails over religious condemns. It is supported under the constitutional law such as Article 14, equality before law, Article 15, prohibition of discrimination, Article 25, Clause 2 states power to regulate secular aspects of religious practices. So I conclude by saying Uniform Civil Code, it crafted with sensitivity, if crafted with sensitivity and constitutional, need not conflict with religious freedom, but rather harmonize the core constitutional values of equality, dignity, and secularism. Thank you and have a nice evening ahead.
Thank you, Sonali Gupta. Before proceeding further, I would like to ask our respected judges if they have any questions for the participants.
No, Gurleen, the candidates can move further.
Next speaker we have is Srinjoy Mukherjee.
Sorry, but I'm actually reading the question. That's why my mic is off. Sorry to the participants and judges. You know why just I got left out of this meeting? If it was by the authorities, first of all, I would like to apologize because of this behavior, and I'm truly saying that is some problem, technical issue, and I'm not doing this. So, if you allow me, can may I just continue with the question, or should I just mute my mic? It's the problem when I just click on the messages, in call messages, I just get out of this meeting. Don't know what's going on. If I just click on this in call messages, I just get out of the in meeting.
Our next participant is Srinjoy Mukherjee.
Good evening, respected judges and participants. Today, as we gather here to discuss a matter of great constitutional and societal significance, the Uniform Civil Code (UCC) and its impact on the balance between equality and religious freedoms. The vision of UCC is mentioned in the Article 44, Clause 4 of the Indian Constitution, which looks towards a single legal framework governing legal personal laws across all religions. This includes issues such as the marriage, divorce, adoption, succession, and property rights, which seeks to bring equality among all citizens by ensuring that constitutional law overcomes the religious practices. However, there are many problems regarding this change. Dr. B.R. Ambedkar, the father of the Indian Constitution, who strongly believed in creating a single law for all irrespective of the religions, but it did not get a proper implementation at the time. The UCC was first introduced in the parliament in February 1951, but it faced several opposition from the public, but also from leaders like Dr. Rajendra Prasad, Sardar Vallabhbhai Patel, Sarojini Naidu, and Sucheta Kriplani. So the two important questions I would like to ask that why does the government want to enforce the UCC even though it is facing so much opposition? And what makes the UCC necessary for the modern India? So India has seen several socio-religious reforms. During the British time, Hindu personal laws were reformed through several changes like the Widow Remarriage Act, which allowed widows to remarry again, and the Hindu Women's Property Act from 1929 to 1937. But still, Muslim personal laws governed by Sharia remained in the system, which is still under the purview of the government. One major concern of the government regarding the Muslim Marriage Act and are particularly the practice of marriage at the age of puberty. The UCC aims to remove such type of disparities and setting the marriageable age of 18 years for all, regardless of the religion, to ensure justice and equality. As India has more than 645 tribes which follow various traditions and customs, any attempt to impose UCC would be a major threat towards their existence. For example, the Naga woman usually marries and shares the property among the same religion, but with the implementation of UCC, they will now share with the people of different religions, and their existence would be a huge question mark in the end. Last but not the least, I would like to conclude with the slogan एक भारत एक संविधान संविधान अधिकार सबका सम्मान धार्मिक स्वतंत्रता का का है मान चले मिलकर लेकर एक नई पहचान. Thank you, everyone.
Thank you, Srinjoy Mukherjee. Next, I invite Srishti Singh